Well, hello and welcome to today's HIPAA Chat. I'm Carol Fogg with High Tech Answers. Thanks for joining us today, especially as we get close to the holidays and everybody taking time off to be with loved ones and family members. HIPAA Chat, of course, is sponsored by eFax Corporate, a brand of J2 Cloud Services. They've been our sponsor right from the start, almost 2 years now doing HIPAA Chat, and without them, we would not be able to bring you this monthly webinar series. They have several products that can help with the secure exchange of ePHI, so please check them out at enterprise.efax.com. Our host is David Harlow. David is a healthcare lawyer and consultant with 25 years of public and private experience. He has a deep background and knowledge, of course, in HIPAA, compliance, security planning for both covered entities, business associates, including providers, vendors, payers, and healthcare systems. We're so glad to have him back again, hosting this month's event. And if during the course of HIPAA Chat you have a question, you can email him offline at david@harlowgroup.net. And you can learn more about him and follow his blog at the Health Blog, BLAWG, healthblog.com. David, it's great to see you again, or at least virtually talk to you again. How about that?
Yes, I'll take it. Thank you, Carol.
I think everybody's attention span is been shaped these days in two ways. First, post-election, and no matter, who you supported, who you could still continue to support. I think everybody is sort of been over-electified. And then, of course, we have the holidays upon us. So I mean it sincerely for the people who are taking the time to attend today's event. We appreciate it. If you're interested in looking at past events, or you're new to HIPAA Chat, this is your first time, you can find all of our previous events on YouTube. There's a URL provided in the PowerPoint, but you can also just, on YouTube, if you type in High Tech Answers channel or Healthcare Now Radio channel, both will pull up all of our previous events on HIPAA. If you're looking for podcasts because you want to download them and listen to them while you're working off your holiday meals in January, please visit our radio station website, healthcarenowradio.com. Under programs page, you'll find HIPAA Chat, and you can download them as podcasts. They're not gated, so you can just download them and rock and roll. And we stream HIPAA Chat live at 12 noon and 7 p.m. Eastern every day on our actual internet radio station, which is healthcarenowradio.airtime.pro. You can find a button or a link or a click through to actually get to our radio player on healthcarenowradio.com. And then finally, you can follow us on LinkedIn. We actually have a HIPAA Chat group established there. We've got, 150 members, maybe 200, where we like to engage followers in all things HIPAA. So David, we promised to talk to our audience today and take questions about the lay of the land. Audits and risk assessments. We're going to be talking about the 21st Century Cures Act that recently got passed and what that means from a HIPAA angle. And then we're also going to be talking about the LabMD case, which is something that you've written extensively about and on your healthblog.com. So a lot to cover, and then of course we're going to get to the registration questions and also take live questions from our audience. Did I lose you?
No, I'm here. Excuse me. So
Oh, no
yes,
worries.
HIPAA audits and risk assessments. As covered entities and business associates know, since the inception of HIPAA, there has been the specter of audits hanging out there. And over the past few years now, we've heard again and again from our friends in government that HIPAA audits are coming. HIPAA audits are coming. And it has been quite a while. They've had some infrastructure issues. They've been putting together some software for internal use in order to regularize this approach to oversight and compliance, and they finally kicked it off. So they sent out letters to covered entities letting them know that they may be subject to audits, and covered entities have had to identify business associates to them. Still hasn't quite kicked off, but it is in process. This is phase two
Right.
of the HIPAA audits conducted by OCR, the HHS Office for Civil Rights, which enforces HIPAA, and they're still doing some of they're taking care of the basics now, because of course on the business associate front, that's a new area of audit concern for OCR since the implementation of the High-Tech Act. So that hasn't been out there before. And of course, business associates are not known to HHS as healthcare providers are, covered entities are. So there's a necessity for getting that information about them from the covered entities. So the some of the learnings from the first round of audits was that many, if not most, of those covered entities audited had not even conducted a risk assessment, conducted and documented, I should say, because that's an important lesson here. Doesn't matter what you need to do and you need to document, because if you are called upon in the event of an audit or other sort of investigation, whether it's a complaint investigation or breach investigation or something else, you need to be able to document precisely how you have been in compliance with HIPAA. So again, compliance alone is not enough. Documentation of compliance is a key ingredient. Um, so the risk assessment is a piece of that, conducting a risk assessment and documenting the risk assessment. And then, of course, dealing with the outputs from a risk assessment. So it's great to do a risk assessment that shows you have room for improvement in categories A, B, and C. You then need to address those categories A, B, and C. Now, the government in this regard are realists and recognize that not everybody can do everything all at once, but it is important to take those outputs from a risk assessment, prioritize what needs to be done, and get to it. Again, it doesn't have to be done all at once, but there has to be a plan in place to address all of those issues. Another sort of basic issue is the failure of many covered entities to have written business associate agreements in
Mm-hmm.
place. This is not something new, and yet a lot of people have sort of left that to the side and not truly complied in full with that requirement. So audits of covered entities are going to be beginning relatively soon, and audits of business associates will be following. Again, as I mentioned earlier, there's a software platform that the government is putting in place to conduct much of this. So much of the audit activity will consist of receiving a document request, responding to questionnaires online, uploading documents online, etc. But in the end, there will of course be some field audits as well.
I think it's so interesting that obviously more than half of these auditors are finding that there is not a risk assessment or plan, which is a tenet of HIPAA and the HITECH Act, and actually can put your meaningful use dollars at risk if you're audited, because obviously that's one of the requirements for meaningful use stage 1, stage 2, and stage 3. So I think, I mean, sort of, considering the number of providers who are in the system uh, for meaningful use, the fact that such a great majority still haven't appropriately addressed this, as tenet of HIPAA.
Right. And to be frank, I mean, yes, there is a requirement to comply with HIPAA, to comply with meaningful use requirements, to comply with MACRA now that it's coming into effect.
Mm-hmm.
But there should also be this concern or awareness of the fact that privacy breaches may be cause for liability under state law lawsuits. If there is a breach, a patient whose record has been breached could bring a lawsuit. And the fact that a party has not complied with all of the HIPAA requirements may be evidence against them. So strictly speaking, there isn't a private cause of action for violating HIPAA. An individual cannot sue a practice, a hospital, a business associate for violating HIPAA, but can sue for a privacy breach, and evidence in that case could be a HIPAA violation.
I'm just curious. Do you think it's just lack of awareness or knowledge, or do you think these providers, especially maybe not on the big medical practice or hospitals, or maybe it is, where they have a form that the patient signs off, the ubiquitous HIPAA release forms, and they think that that's enough? Is it lack of awareness, or they just don't have the time? And I don't want to think that they don't take it seriously. I'm sure they do. I'm just wondering if doing a risk assessment, and there are obviously plenty of tools out there and guidance on how to do a risk assessment. I, I'm just struggling to understand, years into the HITECH Act and several years since the HIPAA Omnibus passed in 2013, the response on this.
Sure. I mean, it's been years and years at this point. And again,
Yeah,
for people in many states, these rules are not necessarily new. HIPAA has sort of organized things in a slightly different way, but with respect to many states, it's not a significant lift above and beyond state privacy law. There are a lot of specifics, and I think people in smaller operations are scared off by the specifics and are scared off by the technology implementation requirements. However, it's not the kind of thing one can ignore successfully for the long term. Certainly, there are a million and one compliance issues that are thrown at
sure.
practice managers and
Sure.
smaller organizations, and these organizations do not consistently have the resources necessary to deal with all of these requirements. That's a whole broader conversation about how is compliance supposed to be funded. If the government is throwing out all of these compliance
Mm-hmm.
requirements and at the same time squeezing reimbursement, what's a provider to do?
Right. Right.
And
Can they even
I don't want to
afford?
joke
Right.
about this, but
Yeah.
this is a real concern, and a consistent concern. So that's not something new. It's not limited to HIPAA, and it's not limited to healthcare providers. Nevertheless, this is the law. These are the risks. This is the potential outcome for noncompliance, and providers, practice managers, others need to make informed decisions about how they spend their resources. And to me, this is some sort of basic infrastructure work that needs to be done, that needs to be addressed.
Figured out. All right. So, and recent to the news, there are obviously, besides just HIPAA breaches that we hear about and cybersecurity threats, those in the healthcare space, not related to Russia or anything like that. The 21st Century Cures Act passed this month, was signed into law this month, and the 21st Century Cures Act is $6.3 billion piece of legislation that deals with funding for cancer, Alzheimer's. It gives states funding to help combat opiate addiction issues, which of course is a huge problem, and other things related to the FDA. But there is a HIPAA angle.
Yes, there's always a HIPAA angle.
There's always a HIPAA angle.
Yes,
That's why we're talking about
always
this,
a HIPAA
right?
angle.
Always.
Right. So 21st Century Cures Act, most of our participants may not have heard about the HIPAA angles to the 21st Century Cures Act. As you said, Carol, there's a lot in there about the FDA, about cancer moonshot, about other things hither and yon within healthcare. But for our purposes today, I just want to focus in on a couple of narrow issues that are related to HIPAA. One, that the first one mentioned on the slide, that business associates are now called upon to respond directly to patient requests for PHI, that is something new in law. There may have been in place contractual arrangements between covered entities and business associates that addressed this issue. But generally speaking, the requirement is that if a business associate receives a request from a patient for information, the business associate generally passes that along to the covered entity. Covered entity deals with delivering data to patients. So this is new. This is something that will have to be dealt with in contractual arrangements, including business associate agreements between covered entities and business associates. I would encourage business associates to take a look at their existing business associate agreements with provider organizations, other covered entities, to see, do they currently have obligations under those agreements to deliver health care information, protected health information to patients if requested. Some business associates are completely unknown to the patient, so it's not likely that they will be asked. But some are known to the patient, and they may be asked. So that's something that has to be addressed in contract, because it will be a requirement for those business associates to respond appropriately to patients.
And then, sorry, go
Yeah.
ahead.
Some of the other issues here are really sort of longer term in terms of implementation, because the law calls for studies and um, reports, and this may take a while. But other things here are going to be implemented in the nearer term, like the business associate agreement requirement. Information blocking, this is something that's been sort of in the public consciousness
Yeah.
in the realm of HIPAA and in the realm of healthcare IT. And there's a specific statement in the law that information blocking is prohibited. And this has gone back to the initial drafts of the statute that were passed by one house of Congress going on 18 months ago. So this is not something that should be new to anyone who's looking at this, but it is now the law of the land. And of course, the information blocking prohibition comes into tension with the general requirement for disclosure of PHI to, the limits on disclosure of PHI to only authorized parties. So on the one hand, there's a dramatic new openness requirement. On the other hand, there's still a requirement that covered entities and business associates release PHI only to those who have a legitimate right to obtain that PHI. So enforcement of one piece of the law, openness, versus enforcement of the other piece of the law, limitation of access, could potentially come into conflict. And it remains to be seen how the information blocking prohibition is actually implemented. The mental health and substance abuse rules exist separate and apart from general HIPAA privacy and security rules, and it will remain to be seen how those two may be further integrated. There are some regulatory developments in the area of mental health and substance abuse. This is referred to as 42 CFR Part 2 rules. There's been some development in that arena over the past couple of years, and now there's a congressional call for HHS and OCR to get together and review the interplay of those regulations further. So again, that's a future
Long
development to
tail. Yeah.
follow. Yeah. There are also some new provisions regarding research-related disclosures, and again, these will have to be fleshed out in regulation, but there are really stricter research privacy protections in the offing, and that will um, that will have to be worked through in regulation, ranging from the NIH having to issue a certificate of confidentiality for all federally funded research, um, and additional limitations on how study data may be used, and a review of what is the meaning of the phrase preparatory to research. There's a HIPAA research exemption that allows researchers to collect information before a research study is conducted. So information collected at that stage of the game is not subject to HIPAA. So we're opening up the books on that again. What does that mean? How broad, how limited should that exception be?
So obviously, uh, more to come on this as we talk about this in 2017 as the bill sort of takes root and flourishes.
Oh yes, and
Yeah, yeah,
there's a new HIT advisory committee established under the Cures Act that's supposed to issue recommendations focusing on uh, privacy protections, including disclosures of PHI
right.
under HIPAA.
And I mean, this bill in the Senate passed, I think, 95 to 4 or something like that. So I mean, obviously, this is this is going to be moving forward.
Yeah.
Um, okay,
Yeah,
finally,
I mean,
before we,
I'm sorry.
oh no, go ahead.
I was just going to say that the 21st Century Act, like MACRA, these are
Right.
pieces of legislation that have been passed in the relatively recent past. Obviously, 21st Century occurs much more recently. But when people talk about health reform and the possibility of health reform being rolled back under the new administration, these two acts are maybe thought of as part of the broader package of health reform items, but they really passed with much larger margins. And it'd be interesting to see. I don't expect that they would be subject to the same sort of rollback initiatives as the um, um, what we call generically Obamacare.
Yeah, the ACA, Affordable Care Act.
Mm-hmm.
Yeah. So finally, before we get into our Q&A, LabMD. So this is a case that you've been writing about on the healthblog.com, and I don't know if it's fair to say it's a landmark case or it's developing into a landmark case or one way or another, but it's certainly an interesting case and has some implications related to HIPAA and cybersecurity and the FTC Act.
Yes, absolutely. So this is a long-running case, several years of administrative and court activity back and forth between LabMD, which is a clinical lab, and the Federal Trade Commission. Now, as folks may know, the Federal Trade Commission has its own authority to regulate in the realm of privacy and security that is parallel to, but um, not exactly the same as the enforcement authority of the Office for Civil Rights under HIPAA. The way the Federal Trade Commission regulates in this area is the Federal Trade Commission does not have regulations specific to healthcare data privacy and security. It has general authority to protect against unfair business practices. And it is up to the Federal Trade Commission to define from time to time what is an unfair business practice. So it has defined in the health data privacy and security realm that insufficient security, breaches of privacy and security are in themselves unfair business practices, which brings them within the realm of Federal Trade Commission jurisdiction. So LabMD, this clinical lab, was effectively put out of business by the actions of a computer security vendor that effectively dropped a dime on LabMD. And as I'll explain, this dime that was dropped turned out to be a bunch of falsehoods. And the Federal Trade Commission ran with that information and brought a significant enforcement action against LabMD, which basically put it out of business. And LabMD, in the latest action, essentially argues that the Federal Trade Commission misinterpreted and misapplied its own legislation because it declared LabMD's actions unfair without properly determining whether LabMD caused or was likely to cause substantial injury to consumers. So all of this was based on a computer security vendor trying to get LabMD as a client. And in the process of doing so, basically targeted not only LabMD, but a bunch of other potential customers, and snooped around online to see if they could find any unsecured sensitive data. They did in the case of LabMD. There was an issue with a former employee who had downloaded some, peer-to-peer file sharing software on the company network. Big no-no.
Oh, yeah.
And as a result of that, this vendor was able to get into the company's system, was able to pull down some patient data, and then posted it online on an unsecured page. Nobody other than this vendor ever saw it on that page. The vendor demonstrated that it was out there to LabMD without saying, oh, by the way, we hacked into your system and
Right,
pulled this down
right.
and posted it online for the world to see. They didn't say that part. All they said was, gee, this patient data of yours is out on the open internet. Anybody could go see it. We can help you fix this problem. And, sign here, pay here. LabMD said no thanks. And the vendor turned around and dropped a dime with the Federal Trade Commission, saying LabMD is breached patient data, blah, 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 go after them. And so here we are 2-3 years later after the Federal Trade Commission did in fact go after them. It's been back and forth with the Federal Trade Commission and the courts, and the current posture of the case is that Federal Trade Commission final order going in saying that LabMD has to do all of these remediation things and put systems in place to protect the data. I mean, remember, the company's been put out of business, so
Right.
LabMD consists of a computer server in a locked room disconnected from the internet, and whenever anybody requests information, somebody unlocks the door, goes into the room, downloads a file from the hard drive, takes it to another computer to send it to somebody. So not a
Crazy.
lot of assets here
To
to
have, yeah.
actually deal with Federal Trade Commission compliance, right? So the company asked the courts to stay the final order of the Federal Trade Commission pending its appeal of that order through the court systems. So the court said, yeah, we agree with you. Federal Trade Commission cannot enforce its order until the full appeal is heard. And by the way, we think that in order to reach that, we have to think that there's a reasonable likelihood that LabMD will prevail when the appeal is heard. And the court said, yeah, we think that that's true because the harm that the FTC is alleging here is entirely speculative. There's no evidence that anybody other than this computer security vendor ever saw this information or released it in any harmful way. And the way that the Federal Trade Commission had sort of twisted the definition of likely, and the court said likely cannot describe a risk whose likelihood to occur is low. It's like, okay, folks, yeah, likely means likely, not
It will
something
likely
else.
happen.
The
No,
Federal Trade Commission said that
not
likely meant something else. It's a little tricky. So if I
likely,
were the Federal
likely,
Trade,
likely, and hardly are not the same thing.
yeah, right. So if I were the Federal
Oh,
Trade Commission, I'd be worried that this court is going to find against them when they actually hear the full appeal, right? So this court order at this moment is a significant challenge to Federal Trade Commission authority in terms of the wide ranging approach that they've taken to data privacy and security enforcement. Doesn't mean they're out of that business, but they're really pulled back in a way that they haven't been before. But it's limited in applicability because this is just a pre-trial motion. It just affects this case and remains to be seen when the court rules on the full appeal whether they will continue to feel as strongly. If
mm.
those judges do continue to feel as strongly, then this really puts the Federal Trade Commission back on its heels in terms of data privacy and security enforcement.
Fascinating case, and you've been writing about it again on healthblog.com, so I recommend people go there and check it out. It really is pretty interesting. Um, All right, so we're going to get our Q&A, and just to remind everybody that if we don't get to your question or you want further clarification, you can email David directly at david@harlowgroup.net. You can check out his blog, healthblog, blawg.com, and follow him on Twitter at healthblog. So lots of ways to reach out and touch you. All right, first question from our registrant.
I can run, but I can't hide.
You can run. Yeah, not man, you're on Twitter, so yeah, if anything we've all learned, you know what I mean? Easy enough to find on Twitter. All right, first and foremost, from question from the registrant, who executes a HIPAA audit, CMS or another agency?
So the agency that enforces HIPAA is the U.S. Department of Health and Human Services Office of Civil Rights. So one side of the house there enforces the civil rights statutes for healthcare purposes, and so that deals with sort of discrimination against individuals based on impermissible classifications, and the other side of the house deals with enforcement of HIPAA. So that's the answer there. It's an office of the um, um, Department of Health and Human Services.
Okay. What should I do with, well, this doctor's been practicing for a while, this provider. What should I do with files from the 50s and 60s that have been kept by my predecessors? No, I'll take that back. To show history of our local health department.
So a local health department has a certain type of records. They're not necessarily individual patient treatment records, although they might be in some cases, but it's sort of other sorts of public records that have been kept over the years from the past. The the record keeping requirements may be set at the local or state level, so I wouldn't put a number of years requirement out there as being a HIPAA requirement, but there would be most likely a local or state requirement. I know in my state, just for example, there's a requirement um, for keeping records, I believe 20 years after the fact for some sorts of records. So again, it's probably set by state law.
Okay. What are examples slash best practices in assembling a security risk analysis documentation for MU audit purposes?
So the risk assessment, whether it's for meaningful use or for HIPAA compliance purposes, are similar. The first step that you should take is really to start with a risk assessment template which you can find on OCR's website, or you can find another one through an organization that's called HIPAA COW, C-O-W. They're from Wisconsin, so that's why they came up with that acronym. And
Guess it could have been HIPAA cheese too, but
I guess so. We have to. So HIPAA has a terrific set of tools, and one of them is a risk assessment spreadsheet that takes you through the process step by step of assembling the documentation that you need and answering the questions that you need to answer, to be able to answer in order to satisfy a government risk assessment. Now, going through that process is one way of doing it. You can also engage a security consultant to do that with you. When I work with clients, I have them go through the HIPAA process first on their own, or I'll do it with them, and then we bring in a security analyst, a security consultant. It's important because going through that process will surface some issues that may translate into some operational issues that can best be addressed before bringing in yet another consultant. So there's a lot can be done internally.
and also HIMSS has a security risk analysis toolkit, so to speak, as well. If you're looking for another free resource, the HIMSS organization have put one out. I don't think you have to be a member to download that.
Great.
Sort of staying on this track, how often should a risk assessment be conducted, or a self-audit, and should an outside third-party vendor conduct the audit, or is an internal audit okay?
So to start with the second question first, I think that, as I just mentioned, an internal audit is definitely a piece of the puzzle. That's something that you should be doing. There should be somebody internal to the organization who can set up the processes as well as conduct an initial audit. Ultimately, you will give others who you are dealing with, whether it's government or business partners of one sort or another, greater comfort if you can point to an audit conducted by, an assessment conducted by a third party with some measure of independence. So that's a helpful thing to do. I've found that cuts down the discussion time, whether it's in the context of an audit, of enforcement, of negotiating a business agreement. If you can point to something that's been done by a third party, that helps move the process along. But again, worth doing internally first, gets your staff informed about what's actually happening on the ground, and can move things forward. As far as how frequently that needs to happen, if we're talking about a HIPAA security risk assessment, not for meaningful use purposes, there's no interval that's required by regulation. I think, however, that it makes sense to do this on an annual basis, or more frequently if there has been a change to the technology infrastructure or to policies and procedures within the organization.
Right, or if somebody perhaps left under not good circumstances or something like that.
Right. Well, there, I mean, I think we're not talking about a wholesale risk assessment, but an assessment of what we might call a security incident, right?
Oh, okay. Mm-hmm.
So not necessarily rising to the level of a breach that becomes reportable and triggers all sorts of other things. But if something has happened and one has questions, the
Yeah.
first thing to do is determine, has a breach occurred? So in order to do that, you need to go through the process of a review of a security incident. And there's a handful of questions that are set forth in the regulations that you need to ask yourself, that you need to examine, that you need to document. Now, the shortcut approach which is sort of more draconian, is to say, okay, yes, X, Y, and Z happened, looks like a breach, smells like a breach, it's a breach. I'm going to treat it as a breach. I'm going to err on the side of caution. And that triggers a whole cascade of other decisions that then need to be taken once you've determined that it is in fact a breach. So another approach is to take a moment at that point and say, well, yes, I recognize that this was a security incident, but is it in fact a breach? Who actually saw PHI? What did they do with it? Um, is it a covered entity, a medical professional who had access to PHI, but then shouldn't have had access for that particular patient? Um, was it used? Was it copied? Did it get out? There's a whole series of types of questions that need to be looked at in order to determine whether this security incident is in fact a breach.
Um, do you happen to know how many points a provider loses under MACRA starting 2017 if the provider checks no or does not check yes for doing a HIPAA security risk assessment?
I couldn't speak to a particular penalty here, but as we know, there's a range of penalties and bonuses that will start at a total of, I believe it's 4%, and go up over time to a total of 9%, I believe. And I think while it may be comforting to know that if I check off these things but not some other things, I will only be hit as much. I would rather encourage people to take the approach of understanding that there's tremendous exposure to liability if there is a failure of compliance with HIPAA. So above and beyond the MACRA hit, there's significant exposure. So just as an example, even a small practice with some HIPAA compliance issues and not even necessarily an actual breach, I'll take that back. In the context of a breach, looking at the practices, and we spoke before about business associate agreements and other things. So there are a handful of issues identified with respect to small to medium-sized medical practices that lead to six-figure fines.
Yeah.
So in the scheme of things, HIPAA compliance is an important issue even at the small provider level.
I mean, if you're that provider and you're thinking, oh, I should check no or not check yes, I mean, that should lead you to the bigger question as to, well, you know, why
Yeah,
I
right,
don't have
exactly.
one. Yeah, that's the bigger, because what's at stake is much larger than your cumulative points under under the MIPS program, you know, or
Mm-hmm.
MACRA. So yeah.
I would agree.
Do you know how many covered, I'm taking a question from a live audience, do you know how many covered entities were audited to determine the 50% plus failed to complete a risk assessment? I don't know how many they've audited so far in phase one and phase two as a cumulative total.
Well, I think that was drawn from the phase one audit results, and that was on the order of, something under 200 audits.
The spot, and phase two is much more I mean, as the phases come along, they're doing more and more.
They're likely to do more audits, but the phase two audits that the indications that we've gotten thus far from the government agency is that there's a handful of specific areas of compliance that they're particularly interested in. Obviously, if they find something amiss, they'll certainly dig deeper, and they have the authority to dig deeper in any event. But the other point to make there that they continue to make, and some folks are not entirely willing to take them at their word, which is, we're from the government, we're here to help. We're not after you. We're doing an audit less to investigate an individual audit subject and more to identify what are the commonalities in compliance or non-compliance that we see among providers and other covered entities and business associates of different types. And then we can help by developing guidance that is unique to those different covered entity and business associate types so that compliance can be improved and data privacy and security can be improved for all. That's the goal. If they find a bad actor along the way, they will certainly
Yeah, sure.
pursue with an enforcement action or at least further investigation. But the overall approach, as articulated by the agency, is otherwise.
Yeah, I mean, certainly they're not going to ignore anything that's, egregious.
Right.
Yeah. Do you know, does an audit of a covered entity increase the risk that the covered entity's business associate will later be audited by OCR?
I would say yes, because the only way that a business associate will come to the attention of OCR is through being identified by a covered entity if it is subject to the phase 2 audit questionnaires, or if there is a complaint, either with respect to the covered entity and the trail leads to the business associate, or if there's a complaint with respect to the business associate directly. So certainly an audit of the covered entity that has identified a relationship with the business associate, either before the audit began or in the course of the audit, it's discovered through its records, that certainly does increase the likelihood that that business associate may be the subject of further investigation.
Okay. Do you have any advice on how to conduct an internal HIPAA audit, especially when HIPAA conflicts with the company culture?
Well, if HIPAA conflicts with the company culture, Houston, we have a
We have a
problem.
problem.
So that's not an excuse to get out of doing an audit. That is a call to action. And by the tenor of that question, I am guessing that this is coming from someone who is frustrated with the lack of a culture of compliance within the organization. And that fact needs to be brought to the attention of the powers that be so that a shift can begin to take place. And that shift needs to begin at the top. And if that person who is frustrated with the present culture needs to find examples of how that culture can lead to enforcement actions that can devastate the organization, we need only look at issues like the LabMD case or
Right.
um, the history of actions taken by OCR against individual practices and other organizations, whether it's the $100,000 fine against a physician practice or the multi-million dollar fines collected from larger organizations. LabMD is not the only company that's been put out of business by these sorts of eventualities. Probably the largest fine, don't know offhand if it's still the largest fine ever, but the largest fine at the time levied by OCR was against a company that ultimately turned out to be bankrupt and unable to pay the fine. But certainly their practices that led to the fine were also related to the company going bankrupt. So the
Yeah.
culture of compliance is very important.
I mean, I think as you said in the phase one, there were, I think you said a couple hundred that were audited as part of the program. Phase two, I think it was sort of tenfold that, but even still, that is a very small number to date compared to the number of covered entities and BAs that are out there. But when it does happen, it's a it's a devastating occurrence, when you have a HIPAA breach or you are audited and there are problems, there are fines. And so you might be thinking, well, what are the chances? And when you should be thinking, it's the law, and if I don't comply and I get caught or there is a breach and, I have to, have to report breaches of a certain level to the media, that this is going to be devastating to fines and my reputation and all those things that kind of go hand in hand.
Right, absolutely. It it shouldn't be, the tail that wags the dog, but to a certain extent it is, and it has to be. And as I said earlier, there are a number of realms of compliance that a particular organization may feel this is not central to what we're doing here, but failure to meet those requirements can be truly devastating.
Right. And it's sort of and there is an HSS wall of shame. So, those breaches over 500 that get reported to the media. Although I'm not sure, do breaches under 500 make it to the wall of shame, or is it just over 500? I'm
I
not
think 500 is the threshold there because that's a sort of a public notice requirement. There's
public
still a
reporting.
reporting requirement for smaller breaches, but the reporting requirements are not as strictly time bound as the larger breaches.
All right, right. Um, if hospitals are fined by OCR, are you seeing if those hospitals are showing a decrease in patients receiving care at the hospital? That is the public relations side of being fined. I don't know if you've
Right.
seen any cases of that.
This is the conundrum, and this maybe leads to some folks saying, I don't really care that much about HIPAA compliance. Um, I haven't seen that in sort of a one-to-one relationship in the hospital setting, um, not even in the sort of egregious ransomware cases, or at least those that have been public. My sense is that there are many other ransomware cases that we never hear about. Um, and even in the what may be the largest breach of all to date, the Anthem breach a year or
Yeah,
so
80
ago,
million records. Yeah.
I don't know that we saw any business impact on Anthem in terms of loss of subscribers.
Well, in fact, they're in the midst of a merger.
Well, that's a whole other story.
Yeah,
The government has put the brakes on
yeah.
that merger, and they're in litigation over that right now. But the um, the salient point here is that I don't think that the breach. I mean, it led to a lot of ink and virtual ink about Anthem and about healthcare and about hand wringing about security and health data. But I don't think that that led to any reduction in enrollment in their plans.
It is an interesting conundrum, as you said. Specific relations on behavioral health records and workers' comps, must these be locked down so other providers cannot view them?
So there are certain categories of health data that are subject to additional restrictions at the state level, and these are two of those areas, two of those subtypes of data that are subject to additional restrictions at the state level. So you will need to review state law for requirements regarding sharing of that information, because the general idea behind HIPAA is that the idea is to protect privacy and security of data, um, except as determined by a patient. Patient wants to release information, patient gets to release information. And the general principle of looking at the federal law in conjunction with state law with respect to a law like this is that if the state law is more protective of the patient than the federal law, then the state law wins, as opposed to the general concept of federal preemption of state law. So there's a state by state and subject by subject preemption analysis that has to be done when you're dealing with patient data in a particular state. Could be with respect to all patient data, but even more so with respect to what we call sensitive data that could include behavioral health and other categories of data. And workers' comp is a creature of state law and is subject to its own state-specific sets of requirements.
We've got one last question before we wrap up today's broadcast. If we didn't get to your question, please email me or David offline and we will respond back one way or another because we did not get to every question. Do you know where we can read about the 21st Century Cures Act? I would like to learn more about the HIPAA pieces that were included in your slides today. I mean, I did reading up, I mean, all the major outlets, news outlets covered it from the legislation side, but more about the Cures Act from the HIPAA side.
Yeah, there isn't a lot out there yet, and as I said, there will be studies and committees and so forth undertaking some work with respect to that. There's a fairly good section by section summary on the committee website. I think it's the Energy and Commerce Committee.
It is energy and
Um,
commerce, yeah.
so that's where I would start. There's a section by section summary of the act there.
Well, with that, we are winding down here. And David, I think we're going to be back in January to kick off 2017. So look for various emails and information on how to sign up for that. And then in February, and we'll be sending some information out right after the year, we're actually going to be doing a virtual panel discussion on cybersecurity. So that should be interesting. And obviously a huge topic. David, I hope you have a great holiday season and looking forward to 2017 with more HIPAA chat. As we said, everything is tied to HIPAA that we do.
Yes, that's great. Thank you, Carol, and thank you everyone for participating today.
Listen, have a good holiday and we'll see you in January.
Bye-bye.